Opening statements are expected to start Monday in the high-profile case against defendant Katherine Reed. She's accused of killing her boyfriend, Boston police officer John O'Keefe, in January 2022 after a night of heavy drinking. Prosecutors argue that Reed backed her SUV into the victim and left him to die in a snowbank outside his friend's house. On the other hand, Reed's defense team believes she's being framed in a massive cover-up orchestrated by both witnesses and law enforcement. Now, keep in mind, a federal investigation concluded that the victim's injuries were not consistent with having been hit by a car. Reed faces charges of second-degree murder, vehicle manslaughter while intoxicated, and leaving the scene of a collision. If she's convicted, she faces life in prison. A 19-person jury has been selected for the trial, but we only anticipate 12 jurors and 4 alternates for the actual panel. On Thursday, a final pretrial motion was held to address outstanding issues, including one about the jury view. Let's take a look at the judge's ruling.
So, as defense counsel plainly states, a defendant is not entitled to be present at a view. And what I've determined here is that based on concerns for security issues and, frankly, distracting the jurors, the defendant will not be present with us on the view. And as you've stated here, that is well within my discretion.
Joining us to break this down, we have criminal defense attorney Serena Townsend and trial attorney Katherine Lizardo. Welcome, both of you. How often is it that a defendant is not allowed to attend a jury? And Katherine, one of the things that I've been thinking about is whether or not there should be a viewing at all. I have mixed feelings about this. Sometimes I think a jury sees the actual scene and is more influenced when they are there because they can sort of feel what is going on. What's your view about that?
Yes, I have a case-by-case basis view of when the jury should see. And here is my understanding, wanted to see the location of where the incident happened. And we know that the allegation is that Katherine Reed backed up, as we see in the video here, during a heavy snow. And so when the jury comes over and sees that, I don't know what the weather would be like at the time that they view it. So the snow might not be there. And, the amount of snow, because he died of hypothermia as well. And one of the interesting fact of his death is that no one saw him out there because of the weather there. So the viewing would not be exactly how it was the night that he died.
Exactly. Well, let's see if she's going to be able to go. Let's see what happens. Now, let's look at another important motion from Thursday. In this argument, the state wanted to introduce a very lengthy screaming match between Reed and the victim while on vacation in Aruba. Here's what both parties had to say and what the judge ultimately ruled.
So, Your Honor, specifically, what the Commonwealth is seeking to introduce there is you have the incident in Aruba, which there are really 4 witnesses who have information to provide to the jury.
Do we need all 4?
Well, so from different perspectives is what I would say. So 2 of them are, the incident or altercation occurs in the lobby of the hotel where the defendant, the victim, and the children are staying along with a larger party of friends of the victim. Following that incident, both children indicate that there's approximately 20-minute screaming match or something to that effect.
Both children were present?
Yes, within the hotel room, and both indicate to that. Then you have the woman, Marietta Sullivan, who's involved in the incident in the lobby, and then you have her sister, who is the person who invited them on the trip in the first place.
So there's some additional testimony from these witnesses too, other than just the statements?
Correct. So the additional testimony from the sister who invited them on the trip, she's not a recipient witness to the altercation. I wouldn't be asking her anything about that. Okay. What I would be asking her about is just her observation. So she had gone out the evening prior with the victim and the defendant to dinner, and sort of the disparity between sort of their demeanor on the night before versus post this incident. And there was some statements that Mr. O'Keefe made to her about sort of the nature of their relationship, or the nature of his relationship with the defendant.
And those statements have been provided to the defendant?
Yes, Your Honor.
There was testimony in the grand jury regarding those statements?
There is, yes. There's state police reports as well as testimony from the witness and the grand jury.
As I'm listening, there seems to be quite a few different categories of information that the Commonwealth is seeking to introduce, and through different means. So, you know, it's difficult to, again, just give one blanket objection or one blanket assent to this. You know, generally speaking, witnesses who would testify about statements of Mr. O'Keefe's state of mind, that probably comes in.
We talked a little bit about that. That's the Qualls and the
Correct.
Bins line of cases. So
Correct.
I did rule that those are coming in.
We recognize that,
Okay.
yes.
You said probably.
Well, yes. Well, Mr.
right.
Lally raised it again, so.
And you don't have to assent. You can object to anything you want to object to, and I make the call. I mean, so you don't need to point out, you know, you don't need to apologize for objecting. Just go ahead and tell me the defendant's position.
Right, I understand, Judge. You know, I think the position here is that we recognize that much of this will come in, but we don't waive the ability to object to a specific question in terms of what it's, you know, what it asks for, how it's phrased, what could potentially come in if the question's too vague. So that's my hesitation on not.
So no, so that's well taken. So even if you assent to it, doesn't mean that if a question crosses the line, you're prohibited from objecting to it. I've never done that before.
That's my point.
Yeah, so you haven't tried before me before. I would not do that. So I find that, let's say for the Aruba statement, all of these go to state of mind and motive. I will give a limiting instruction. I will make the findings that I need to find pursuant to Commonwealth versus Samir. It's a footnote in that case. It's footnote 8, I believe. I will make those findings at the time. There's certainly been a sufficient showing from the Commonwealth. So I will give a limiting instruction. I will welcome proposed limiting instructions if you want to file them. I know you're all busy. If you don't want to, that's fine. I can handle that. Regarding the animosity, again, it's close in time. It goes to the nature of the relationship. I will give a limiting instruction. I'm confident that the limiting instructions will be followed by the jurors, that they're understandable. I will make observations at the time, and if they appear to be understanding and nodding, which you often see on limiting instructions, I will make those findings as well. But I'm satisfied that the jurors will be able to understand a limiting instruction and use the testimony only for the intended purpose. And the animosity goes to the nature of the relationship, goes to the domestic violence line of cases. And the argument being the last thing that the defendant says she recalled, and the children's testimony regarding ending the relationship, again, that goes to state of mind, and it goes to the Qualls and Bins line of cases. And I will give a limiting instruction. I'm confident the jurors will understand. So that's my ruling on that.
All right, that was the ruling I have with me, Serena Townsend, and trial attorney Katherine Lizardo. I'm going to go back to you, Serena. The judge said, yes, and I'm going to give a limiting instruction. Do you think that the jury will listen to that limiting instruction, or are they going to listen to this argument between the defendant and her husband and think, oh my goodness, she killed him?
Right. And so the point of a limiting instruction, of course, is to tell the jury that this evidence is being offered not because we're saying that she did kill him, but to understand the state of mind of the person who made that statement. We always worry that juries are just going to ignore those limiting instructions, and judges always seem to have so much faith that a jury is going to listen to those instructions. I don't know that a jury fully appreciates the distinction between what they're allowed to use that statement for and what they're not. But the judge is just going to basically say, this is our judicial system. We have to trust the jury.
Exactly. And Katherine, the question that I have for you is, how do you determine how many instances in the past you want to introduce as the prosecution? Because that could work against them as well on appeal if too many past instances, multiple arguments, fights that they may have had, 911 calls. If you have too much of that, we know that on appeal, that could work against the prosecution, correct?
Correct. And here we heard the judge during her ruling specifically say, and rightfully so, that she's allowing this past argument that the defendant and the victim, John O'Keefe, had in Aruba because it's close in time to when the incident happened. So being close in time is crucial because, like you mentioned, we don't want to hear an argument between the two of them 2 years ago or 3 years ago. Couples argue, and so just because you're arguing at one time doesn't mean you killed that person later on. So that's the prejudicial effect if everything that they argued about is brought in court. So here, because it's an isolated incident close in time, the judge allowed it with the limiting instruction that it's only going to show the state of mind of the defendant and also the motive for possibly killing O'Keefe.
Exactly. You know what, Serena, another key ruling involved the federal investigation into the case. The judge permitted the state's motion disallowing the defense to directly reference the probe or the fact that the lead state police investigator who's expected to testify is under an internal affairs review. The judge did say, however, that she may permit certain aspects of the state police review to come in after examining information related to it. As far as the federal aid, only to, quote, prior testimony. The ruling sounds a lot like ambiguity, and it's clear that some material in the federal investigation could help the defense. Do you see this becoming an issue down the road?
I do think it could be an issue. I think that there's some information in the federal investigation that is extremely helpful to the defense. Apparently, the investigation stated that the death was inconsistent with being hit by a vehicle. I mean, that's the entire prosecution's theory. So my hope for the defense is that they'll be allowed to elicit something with respect to that investigation to help them.
That's a great point. All right, we have to take a quick break, but don't go anywhere as we recap bombshell testimony in the Doomsday Cult Prophet trial of Chad Daybell. We'll be right back.